We submit that is so far-fetched. And it's not the fact that there was always illicit trade, there always will be. That just supports our argument. It supports our argument that you're now going to have supply continuing. Not going to stop. And as long as that supply continues, there's nothing left of the argument for the respondents. So we submit that as we've said in our heads, the golden thread here that unravels the entire argument for the respondents is what we submit is an incontrovertible fact, that banning is not going to put an end to the supply. And now we weigh up. So if we know that, and there's what is left of the argument? There's a possibility, no more than that, as suggested by literature, not proven anywhere in the world, that smoking might possibly, in some world that we're not told how, might possibly increase the burden on the health services. Well, you can't change that if people are going to continue smoking because they can get it. But that's what you told in the one side of the scales. So on the one scale, the minister's argument is only one. Let's weigh up now all the other considerations that have to be taken into account. The economy, employment. Huge, 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 huge. You're talking about billions. And then let's weigh up the health. If we're looking at health and we're so concerned with health, let's consider the adverse health consequences by virtue of the ban. What it's now doing, one saw it with alcohol. People were drinking the most adulterated substances, causing enormous harm. People were dying from it. And with tobacco and cigarettes now, that's exactly what will happen. Because when you can exploit a market, and you're not controlled by the tobacco legislation, and you've got free carte blanche, this is heaven for the illicit trade. They can charge what they want, they can mix it with whatever they want, they can make it more addictive, because then they hook people in. All sorts of narcotic substances can be and are mixed with these substances. And now we're into a completely uncontrolled, unregulated, toxic environment. And we're looking at health hazards and an increase of the burden on the health system. We submit it doesn't require terribly much thought to see where this balance lies. And we've identified in our heads many of the considerations which we say have been ignored. So when we consider the rationality or reasonableness or justification for the ban, what is it going for the justification? Very little, if anything. We submit nothing really. And nothing certainly that outweighs the enormous other consequences that we are suffering on an ongoing basis. So we submit with respect that her explanations, and I'll deal with them very briefly. Explanations such as, we were going to put an end to supply. The way to put an end to supply is stop people smoking. Stop people smoking will drive down the prices, and it will no longer be a lucrative market. It's very difficult to give any credence to such an untenable proposition. Any basic common sense would indicate that there's no realistic prospect in the real world, and certainly during the lockdown period, of stopping people smoking. There's no realistic prospect that you're going to stop the supply to people who need it, who are addicted to it. And yet there's a complete disregard for the enormous emotional, psychological, physical impacts that this is having on people. Times are stressful enough under lockdown and the restrictions that we have in a responsible fight against COVID. And people now have to also contend those many millions. We're not talking about a few people here. There was as an extra page, there were 600,000 people who signed a petition in no time opposing the ban. That was disregarded, but apparently first it was said to be 2,000 representations pro the ban, then it became a couple of hundred, and many of those apart from the duplications that she put into her papers and the record, indiscriminately so. Ultimately, it transpires when you look at those representations opposing the lifting of the ban, many of them were not saying we are resisting or opposed to lifting the ban. Why are you lifting the ban for cigarettes but not alcohol? And that was interpreted as being opposed to lifting the ban. One has to be very careful. But the 600,000 people almost that signed a petition, they ignored. That didn't seem to be of concern. And we submit, when we read the second response answering affidavit and the reasons for decision, scant, if any, regard was given for the countervailing considerations. All these other enormously prejudicial, detrimental considerations. Lord, my ladies, we don't suggest, and nobody with respect could responsibly suggest, that there isn't any validity in the concern about the hazards and effects of smoking. Of course there are. There's hazards from driving. Every day we take our lives in our hands. There's hazards from living, from consuming certain beverages, from eating certain foods. But that's what life is about. It's about a balancing, and it's about a realistic balancing. You do take certain risks because on a balance, it's considered rational and justified. And that's why we've described this as a sledgehammer to beat people into submission, because that's what it is. To force people immediately to go what they call colloquially cold turkey on smoking. It's an act of cruelty. And people are desperate. And this explanation now, that it spreads it actually fights the spread of the disease because you're going to stop people sharing cigarettes. You've got to credit people with some intelligence. If anything, when people can't get the substance, there'll be more sharing. It just makes absolutely no logic or common sense. But that's the type of explanation we've got to read. At that level, to say, as Dr. West points out, if you want to look for high risk factors, take a cell phone. Studies have shown thousands of times a day people are lifting it to their faces. That is a cesspool of germs, bacteria and viruses. You don't ban cell phones. Why is it that tobacco keeps getting targeted? It's become an obsession. So we submit with respect that none of the reasons given by the second respondent passes rational muster. And the regulations and the DMA is not there for the minister in her discretion to think it's a good idea. And it might possibly, in her world, be an answer to stop people smoking entirely. There may be an answer to her that if you do that, you're going to reduce the burden on the health services. Well, that's in a make-believe world with respect. That is unachievable. In a real world, to imagine that you're going to stop people smoking through this ban is entirely far-fetched. And if this court were to uphold that, it would be to be supporting the proposition that the ban has that effect. That it has that effect that it's going to stop smoking and it's going to drive the illicit traders out of the market. While we submit on no possible basis can that be found.
Procedural. Could I just clarify something based on what you're submitting now? You're arguing a rationality now, correct?
Correct.
The minister in paragraph 89 of the answering affidavit says something about how we as a court should approach the medical literature. She says, our approach should be whether there was any literature that she looked at, and whether based on that literature it can reasonably be concluded that smoking presents heightened COVID-19 risks. You have that paragraph.
I've got it, yes.
What is your comment?
So first,
Is she stating the test correctly?
sorry, my lord, I couldn't
Is
hear.
she stating the test correctly?
No, as I was going to submit. Firstly, it's an objective test. The court has to find that there's a sufficient basis shown, factually, scientifically, through proper evidence, that this is necessary, the ban. So the fact that she may have consulted and formed her own opinions about what the literature may or may not be suggesting, that's not good enough. And she's wrong with respect that when she says not the role of the court to weigh up. Of course it's the role of the court. So we submit with respect that her approach is wrong. The test is wrong. She's urging the court to not second guess her, to be completely differential to her as a secondary legislator, and that if she thought that the material does support what she's saying, well, that's good enough. It can never be good enough.
Don't the authorities, the cases, the long line, from pharmaceuticals, Batista,
Yes.
saying when there's something of an expert nature, shouldn't the court defer to the experts rather than impose its own view? Isn't it what she's saying here?
No, so what your lordship's talking about, and we quote those cases in our heads, where there's a specialist body, for example,
Yes.
then the court should generally be differential. It's still got to be rational, even then they'd have to show. They can't just jump to their own conclusions. But this isn't the case. She's not an expert in this field.
Yes.
She's a Minister of Cooperative Governance. This is a sui generis position. We're not dealing here with an expert body. In fact, if anything, what we do know, the advisory committee, and this isn't so contradicted, we've said the advisory committee must have advised the President before his announcement, when he announced that the ban was going to be lifted. He must have been advised by, he's got a committee of scientists, he's got of experts. That, with respect, is not challenged. When we say he must have been advised by people in the know and by experts, that's not challenged. The only answer we get to that is when the President said what he did, we shouldn't have understood that as a decision finally. We should have understood that as him saying we're going to continue with our consultative process. Well, that's just false. There was nothing suggestive when we've got the transcript of the President's speech. There was nothing suggestive that it may be lifted. It was going to be lifted, and he no doubt wouldn't have done that unilaterally. He's given no affidavit in these proceedings, and we've said in our papers, and we said in the supplementary affidavit, no doubt when he made that announcement, he must have been acting on advice from the experts. So to answer your lordship, firstly, she's not the expert on this. So it's not a differential matter at all, where the court has to defer. But even if it were, what she's saying in that paragraph is, if it's good enough, if I found some literature in my download from the internet that suggests that it may, that's good enough for rationality. We submit that's the wrong test.
Let me take you back to one other aspect that you argued earlier. I just didn't want to disturb you.
No, thank you.
As to why she went for the ban on tobacco products. She mentions that, and I think you argued that there are about between 8 and 11 million smokers in South Africa. I think that's what you argued, and you said you can't just shut out that number of people and expect they'll stop smoking. That's your argument.
Correct.
She says, of the 8 million smokers in South Africa, I think she says 1% of them. If 1% of them were to require medical assistance, that would overwhelm the available healthcare facilities in South Africa.
Yes. So that's purely hypothetical, because she's got no basis for saying 1%
Yes.
will require ventilators. As West points out, it's a completely unreliable exercise that.
Yes.
He says, firstly, you're not going to have 1% all in the ICU at the same time. Of the 1% of smokers, or the category she's talking about, how many of them have other conditions? 80% or 85% of people don't require hospitalization. 80% don't, 15% may but don't need ICU. So there's a very small percentage of people ultimately, and as he explains in his affidavit, and we'd ask, no doubt the court will have very careful regard to what he's saying, because it's not a question of a different opinion. He's doing a purely observational exercise. He's showing that, in fact, it's a completely irrelevant statement, that, because you're not going to ever get 1% at the same time in ICU needing ventilators. So on that proposition, with respect, it's not established anywhere, and it's a totally unreliable statement.
When you say unreliable, because you see, we've got to decide this matter on the facts that have been presented to us. She's mentioning the figure of 8 million smokers. With no facts. You say that's hypothetical. She says South Africa has about 3,500 ventilators, right? And 1% of 8 million. That's what she says. You said that's hypothetical. We shouldn't take cognizance.
So what I'm saying is there are no facts to support a bold statement that there could be 1% at the same time requiring ventilators. That's what I'm saying.
Just on the fact that the president hasn't signed an affidavit, we don't have any evidence why he hasn't.
No.
But your clients make much of this point. Are we being invited to speculate?
No, I'll tell you where the relevance lies with respect. So we're quite mindful that not every party has to depose to an affidavit.
Yes.
See, from that you wouldn't draw an inference.
Yes.
However, there's something else screaming out for an explanation from him. He's the one who made the announcement that it was to be lifted. You would assume that he'd have some rational basis for having made the announcement. In other words, he would have been advised by the experts on this.
Yes.
He wouldn't have simply made an announcement that's going to be lifted without a proper consultation, thought being given, and being advised by the experts on this. Now, that's why we say in those circumstances, an absence of an explanation is important from him. Because her explanation is with respect to non-explanation. She says he mustn't be understood to have been saying categorically. He should have been understood as meaning we're still going to have a consultation process. Well, Faye didn't say that. But it's far more important what we're saying is not said. When we say in our papers expressly that he would not on his own unilaterally have just made that announcement. In fact, he singled it out. When one looks at that announcement, it's the only thing he really focused on at the beginning of that speech, to say that's what's been lifted under the next level. And when we say, because we don't know the inner workings, we've asked for minutes, it's been refused. We've asked for other documents, they've been refused. When we say he's a responsible president who would have made the announcement on an informed, considered basis, that, with respect, cries out for an explanation. For him to then say, or somebody to be able to say from personal knowledge, it was an uninformed statement, or, in fact, I didn't have sufficient, or the experts didn't know enough, or they changed their minds. But we don't have, I can speculate from here to eternity. We don't have any of that. So what we say, submit to your Lordship, is that the mere absence of an affidavit isn't of any relevance. But it's the absence of dealing with what is calling out for an explanation. That's what's of relevance. And that's the significance of why we make much of the fact that he hasn't deposed to an affidavit. Because he's the person who should be justifying why he said what. And we don't get an explanation from the second respondent. Lord, I see it's just after tea.
Thank you very much. We'll take our constitutional tea break.
Thank you.
We'll come back in 15 minutes.
and should have been taken into account, which with respect haven't, and certainly haven't accorded the weight that they deserve. Lord, my ladies, before I continue, might I, it may be of some assistance to the court, we've prepared a chronology, and perhaps we can hand it up. It gives the relevant dates and a reference in the record where you'll find these particular events. Hopefully it's of some assistance.
Thank you for that, but I think your instructing attorneys can also upload it on the case file.
We'll do that, thank you. So,
no, my colleague tells me it's already uploaded.
Oh, I see, thank you. So, if I may then just pick up, dealing with this balancing act and the various considerations, we do deal with the ad ultram partem in the context of procedural rationality. And without belaboring it, the point is this, that after the original announcement was made that the prohibition was to be uplifted to the next level, there was a very short period of time, and it appears from the chronology exactly the number of days, between then and the second respondent addressing, where she indicated that there's going to be a framework and they're calling for representations and people who want to make representations now. And then it was only about 2 or 3 days between then and the decision to prohibit. What's rather remarkable about that is, her first explanation was she had got these thousands of representations opposing it, and that and the available literature, and we know certain of that literature wasn't even available at that time, persuaded her to change the stance that had originally been taken in announcing the lifting of the ban. Now, the fact that in so short a period, a couple of days,
6 days.
Yes, that there could have been that about turn on an enormous amount of literature and scientific evaluation. But perhaps what's most important is that once the announcement is made by the President, people would obviously then consider they don't need to put in representations to support the lifting of a ban because it's already been announced. So the answer from the respondent, well, no, she announced a couple of days later that there's going to be ongoing consultation and that FITA put in representations, but they're an industry body one would expect. But it goes without saying, it's a matter of logic.
But her request for representation was after the President's announcement.
Yes, that's the point.
Yes.
And the point is, at that point in time, and it's a really short space between that announcement and when the regulation was promulgated.
Yes.
So we make 2 points of this. One is, if one look at it a pure Audi approach, and it's just a factor. It doesn't have to be determinative, it's just a factor. Anybody who would have been in favour of the ban being lifted, the people who are addicted to the product would have been relieved to the others. They wouldn't have thought it necessary to put in representations because it's a matter of common sense, basic logic. They've been told it's going to be lifted.
So why would she ask for representations? And why would someone not make a representation, even though the President announced 3 days earlier that this is going to be allowed?
Correct.
But 3 days later, the minister responsible for the department says, tell me what you think about the banning of.
Yes, but that doesn't, yes.
So why would someone sit back and say, well, the President has already announced, I don't care why she wants representation?
But she wasn't sufficiently unequivocal. What she wasn't unequivocal about is that what the President said is no longer going to be the case. We're going back to the drawing board. It's going to be a new consultation process. Yes. The only point, and I'm not trying to overstate it, I want to simply make the point that between the announcement and her announcement, nobody would have thought it necessary, that's all we say, to make representations. Then the way she put it, that we will still consult about it, very equivocal really, as to whether or not the President's announcement is no longer the decision. So we just raise that as a factor that we submit is relevant, not in itself determinative, but it certainly goes to the approach and the rationality of it. And then we get to this question in rationality of criminalizing the conduct. And we deal with this from paragraph 95 of our heads. And the response from the second respondent is you didn't make out a case for criminalization. Well, this is legal argument. We read the regulations. And when you, as the court, assess here the various factors pro and against the ban, certainly one thing you take into account in proportionality is this something which now those who are addicted, who suffer a medical condition, and others who smoke, should they now be convicted and sentenced up to 6 months and or a fine for participating in the sale of this product? And we submit again, may not be determinative in its own right, but a very important issue, as the case law reflects, and we've given references to De Beer and a number of decisions which show the undesirability of criminalizing conduct, particularly through delegated legislation, and particularly where the activity is otherwise lawful. Let's not forget that the starting point here is that the sale of cigarettes and tobacco products is legal. And now what you're doing is, in respect of people who are addicted and in regard to this whole industry, you're criminalizing something. Now, if the need was so great that that drastic measure was necessary, then maybe there's an argument. And that's why ultimately it's a question of valuing, it's a value judgment and weighing things up. And we submit, when you look at the motivation for the ban, it is so weak. The risk of an increased burden on the health system is so tenuous, at best, that then to have as one of the consequences now that people are turned into criminals is with respect to a very undesirable state of affairs. And it does impact upon rationality. And that is what those cases have stressed. And we submit that there needs to be judicial control and oversight over conduct of this nature, where a person takes it upon themselves to make what otherwise is a legal, lawful activity and a medical condition and summarily criminalize it. And we submit with respect that is irrational. The separation of powers, and His Lordship, the Judge President presiding, put to me this question of being differential. We deal with it. We deal with it from paragraph 106 under separation of powers. We're very mindful that there's got to be a separation of powers when you defer to expert bodies. A, we submit, she's not an expert body in that sense, but B, in any event, even an expert body has to act rationally. And we submit that there's nothing that justifies it. The onus I've already addressed, and we submit the onus is squarely on her, at least, even if it were to be an evidentiary burden, she would have borne that onus. And we submit with respect it falls. The conclusion then, Lord, my ladies, is we referred to the judgment recently in this division of His Lordship, Mr. Justice Fabricius, which no doubt you're familiar with. So I don't need to read it. But His Lordship made, with respect, a very, very strong and compelling statement about what the effects are. And this is what, again, in working out rationality and proportionality and whether something's justified, one should also have regard to what the effect is of this type of conduct, which doesn't enjoy the support of the community. When this is a common fight, where you should be in a partnership position, what we find is a particularly secretive process. It's rather worrying when this is the common fight and you're not letting to facts and figures and information. The irresistible inference is there isn't any factual information that's relevant. That's why it's being withheld. But we are told, essentially, when we asked for minutes of these meetings of this body and the committee, we're told it's top secret, state secret, you're not entitled to it. But the whole process has been a very secretive one. And with respect, that's not appropriate in our type democracy, and particularly where we are all fighting and we're victims of this crisis. We're in this together. Regrettably, the approach that's been taken is, as His Lordship warned against, that you will turn this into an economic wasteland. If we continue with these sort of punitive, draconian measures without buy-in from the community, without support from people, the right-thinking people who don't see any rationality in something, you're then going to destroy the purpose. You're going to undermine the purpose. And as I indicated earlier, if there's to be any concern for the health services, it is through this new illicit product, blossoming industry. That's what's going to increase the burden. People are now unregulated, not controlled, and as His Lordship says, you're going to lose the credibility, you have a disrespect for the rule of law, and when you're trying to fight a pandemic, as we are, what you need is education and you need people to cooperate. What you don't need, and that's counterproductive, is hammering people with a sledgehammer, beating them into submission and dictating to them what they will or won't do. And we submit with respect what we set out in paragraph 119, the quote from Impepe's causes case, we submit is particularly opposite to this conduct. And His Lordship concludes in paragraph 9 that we've quoted, thus if government is held to these constitutional obligations and the citizens' trust is restored and lawful rational regulations are obeyed, the expected flood of litigation will retreat and the spread of the virus will be contained until the appropriate vaccine is found. The fact of the matter is thus simply the following: communality or failure. And we submit what we're looking for is communality. This approach, irrational, is doomed to failure. And it's undermining the entire fight that it's so nobly set out to achieve. So we submit with respect that, going back to the amended notice of motion, which in volume, I think it's 6, page 1, the relief that we seek is in prayer 2, 6-2. We've addressed the court on why we submit they are essential goods. And as far as 3 is concerned, if you bear with me a moment. So I'm just waiting for an instruction, if I may ask for one moment. Thank you. Yes. So the cost order that's sought in prayer 3 stands. And we submit that the engagement of 3 counsel was justified. It's been, as the court will have seen, a great deal of work in a very short time, and it was a reasonable precaution to engage 3 counsel. Our learned friends, if I'm not correct, I think they got 4. So we persist in that relief, as the court pleases. Thank you.
Ladies, one fact that we should not forget in deliberations on this matter is that we are dealing with a new pandemic which is ravaging not only this country but the whole world at a rapid rate. So the responses that those who have the responsibility of looking after the lives, the health and the lives of the country have to take that reality into account. In other words, the responses have to be proactive, and the responses have to be swift. We don't have the luxury of having inquiries that will take time and that will consume resources of the state before action is taken. Action has to be taken on the basis of what is known. Although the body of knowledge is increasing, what science tells us at present and what science tells us is probable has to guide the actions of the state. Lord and ladies, we shall rely in our address mostly on the supplementary heads. For one thing, they are shorter, and secondly, they effectively in our submission deal with the submissions by the applicants. We first deal with the applicable standard of review, and that is to be found in paragraph 3 of the supplementary head and paragraphs 35 to 39 of our fuller heads of argument. And our main submission in this regard is that the minister's decision to promulgate regulations pursuant to section 27(2) and is executive action and is subject only to legality review. Our learned friends appear now to accept that proposition. Although in their heads and in the affidavits that were filed, there appeared to be a suggestion that the decision might be subject to parja review, but that has been thankfully abandoned. In paragraph 7 of our head, we reiterate that the minister's decision to promulgate regulations pursuant to section 27(2) of the Act is executive action for the reasons set out in paragraph 37 to 37(6) of our heads of argument. And FITA's only response to this is a bold assertion that the decision is not polycentric. However, FITA itself also contends that the minister is required to weigh a number of competing considerations. In other words, we submit that it cannot have things both ways. The minister's task involves striking a balance between a number of complicated economic, medical, and social considerations so as to protect the public from the devastating effects of the pandemic. And we submit that by that token, that decision is manifestly polycentric. Now, with regard to the onus, our learned friends quote.
Sorry, I'm going to address us on an expansive basis on the rationality
Yes.
of the decision
Yeah.
later.
Yes. Yes. The applicant quotes the decision of Moise as authority for the proposition that the respondents bear the onus to justify the lawfulness of the regulations because they are a restriction on otherwise lawful activity. We submit that Moise is not authority for that proposition. What in fact Moise says is that once a limitation of a constitutional right has been found to exist, the state bears the burden of justifying that limitation in terms of Section 36 of the Constitution. Therefore, there's no general onus to justify a restriction on otherwise lawful activities. The justification onus arises only if a limitation of an identifiable right in the Bill of Rights is shown to have occurred. And we submit that no such limitation has been established. In fact, in this case, our learned colleagues have upfront indicated that theirs is not a constitutional challenge. Otherwise, obviously, they would have had to file a Rule 16a notice, etc., and indicate what right is alleged to have been infringed.
So what do we have then? The restriction on the sale of tobacco products. What is it? Is that a restriction? That's all there is to it, or what is it?
Yes, it's a restriction of the sale of tobacco products for a limited time in order to achieve certain purposes which are stated.
So you argue that it's not a limitation because that's not the case made out.
That's not the case made out. Yes. In any event, Lord, if one pleads a limitation, and the authorities are quite clear on this, the person must identify the right in the Bill of Rights that is alleged to have been infringed. And there's no such allegation in the papers. That's not the case that is being brought. I know that in other matters, which are before other courts, the right, for instance, mentioned in Section 22 of the Constitution of the Bill of Rights is alleged to have been infringed. In another case, they refer to the rights in Section 12, subsection 2 of the Constitution. But this is not the case here. No such right has been put up as having been infringed. Now, in their heads, dealing with the question of ultraviolet and the empowering provision, FITA argues that Section 27.2 does not confer an express power to restrict the sale of tobacco products. The minister has no such power. And we dealt with that in paragraphs 113 and 115 of our main arguments. But FITA makes this submission on the basis of the maximum Expressio unius est exclusio alterius. Now we deal with the fact why that is not applicable. We refer to the matter of the case of Zenzile,
this in response to the reference to alcohol?
Yes.
In the
Yes.
regulation?
That, in the Act.
In the Act, yes.
In the Act, yes. Yes. They say because there's a specific reference to alcohol and there's no reference to cigarettes, therefore there's no authority to restrict or prohibit the sale of tobacco and tobacco products. And we, in paragraph 19, we deal with reasons why that cannot be the case. In paragraph 21, we submit that the purpose of the general power under section 27(2)(n) is that the legislature could not possibly contemplate every sort of disaster that may occur and attempt to confer specific powers relevant to all disasters. That's why 27, as a mistake there, it should not be 28, it should be 27(2)(n) empowers the making of regulations regarding, and I quote, other steps that may be necessary. We'll come back to the wording here of may be necessary to prevent an escalation of the disaster or to alleviate, contain, and minimize the effects of the disaster. The legislature was not able to predict with absolute certainty what steps may be necessary in a given situation, and so elected to leave this within the discretion of the minister. And we submit that on that score, the interpretation by FITA is unduly narrow and runs contrary to the purposes of the Act. If in fact FITA is correct, we submit that the minister could only ever limit the sale of one class of goods, namely alcohol, regardless of the disaster and regardless of what was necessary in the circumstances. We submit that that's an untenable proposition. We then deal, my lord, my ladies, with the question of necessity. FITA argues that the impugned regulations are not necessary as required by section to which I've referred in section 27(3). This requires, firstly, determining what necessary means, and secondly, assessing whether the regulations meet the required standard. And this we have addressed in our main heads, and I'm not going to repeat. This is from paragraphs 116 to 137 of the main heads. And also at 120 to 131 of our main heads. We submit that the test of absolutely necessary cannot apply where the minister makes regulations to deal with a pandemic situation in terms of section 27(2). Instead, we submit that the regulations must be necessary in a sense that they are reasonably required in order to meet the objectives of section 27(2)(n) and 27(3).
Do you have authority for that proposition, that we should understand necessary within the sense of reasonably required?
Lord, we deal with that in the main heads. If we can just go to the main heads page, at paragraph, from paragraph 116.
The page number, the case line's page number.
013. It's 013 and page 58. Yes. Yes. Where we state the following. that at 120, the question is what the applicable test is. When will a regulation be considered necessary within the meaning of these provisions? There is, to the best of our knowledge, as yet no reported case concerning the meaning of the phrase may be necessary in 27(2)(n) or the word necessary in section 27(3). Later on, my lord, my ladies, will show that there is a constitutional court's decision which interprets a different section of the regulations. We dealt with this in our original heads and in our supplementary heads, and my learned friend has referred to that decision in his argument. We submit that the term necessary has been interpreted in other legislation. It has been held to mean, on the one hand, indispensable or absolutely necessary, or on the other hand, reasonably necessary. Much depends, we submit, on the context. We deal with the case of Congo, in which the Constitutional Court considered the meaning of necessary in section 84(1) of the Constitution. That section 84(1) gives the President the powers necessary to fulfill the functions according to him. The Constitutional Court held that the necessary powers conferred on the President by this section were only those powers reasonably necessary to properly fulfill the functions endowed by section 84(2) of the Constitution. Then we deal with other cases. In Ndlovu, we deal with a Namibian case presided over by the former Chief Justice Mohammed. This is paragraph 122.4. In the Namibian case of Atchison, the court interpreted the meaning of necessary in a provision of the Criminal Procedure Act, which provided that a court before which criminal proceedings are pending may from time to time during such proceedings, if the court deems it necessary or expedient, adjourn the proceedings. The court held that the word necessary meant reasonably necessary in the circumstances of a particular case. This is obviously to be contrasted with expedient, which it held to mean what is advantageous, proper, or suitable to the case judicious. And we also refer to the case of Mantiginga interpreting the Ciskei Constitutional Decree of 1990, where the court held that a restriction of a fundamental right applies only insofar as it is strictly necessary for protecting the values enumerated in the restrictions clause. I pause here, Lord and ladies, to mention that in the PECO decision referred to in our heads and by our learned friends, the constitutional right that was being protected in that matter was the rights conferred by section 26(3) of the Constitution. And as we have submitted, in this case we are not dealing with the protection of any constitutional right. In fact, we do mention that case in the next paragraph, that in PECO, the Constitutional Court stated that a municipality's power used a different provision of the Act, 55(2)(d), may be exercised only insofar as it is strictly necessary for the purposes set out in 55.3. That means that the powers concerned may not be used for purposes other than evacuation. As my learned friend has correctly pointed out, the section in 55.2d of the Disaster Management Act dealt with evacuation. And what the municipality did in that case was not to evacuate in that sense, but it was to evict people and demolish their houses. That was obviously yes. The section in the Act relied upon was the evacuation to temporary shelters of all or part of the population from the disaster-stricken or threatened area, if such action is necessary for the preservation of life. That is the section that was being interpreted in PECO. And what the municipality did in that case was not to evacuate the people, but actually to evict them and demolish their structures. So obviously, in that case, the action of the municipality were unlawful. Well, we submit that the courts did not, in fact, squarely consider or deal with the meaning of the word necessary. And we submit it was not actually necessary to deal with it. Or as we say, it was not strictly necessary to deal with it. And to that extent, we say that that expression, strictly necessary, might actually be regarded as obiter in that case. The statement it makes is made in answering the question whether the municipality's powers was exercised for the authorized purpose, not whether the exercise of that power was necessary. And we continue dealing with that. Now back to our supplementary heads at 02011. God will bear with me. 24. Okay. Our attention is being drawn to what follows in our original heads, 01362, paragraph 124, where we say we submit that necessary in sections 27.2n and 27.3 means reasonably necessary rather than absolute necessity or indispensability. And we say so for a number of reasons. The first one, that a proper interpretation of the legislation gives effect to the purpose of the Act and broader legislative context, and prefers a sensible meaning over one that leads to insensible or unbusinesslike results or undermines the apparent purpose of the Act. And we refer to the Ndumeni municipality case, the Constitutional Court. Further, legislation must be interpreted so as to promote the spirit, purpose, and objects of the Bill of Rights. An interpretation that falls within constitutional bounds must be preferred to one that does not. the scheme of the Act is to provide mechanisms for effective disaster management. In Section 26(1) places primary responsibility for coordinating and managing national disasters in the hands of the national executive. In terms of 26(2), the national executive is given broad discretion to deal with a national disaster in accordance with existing legislation as augmented by the regulations or directions made in accordance with Regulation 27(2). Regulation 27(2) in turn confers a broad discretion on the designated minister to make regulations, issue directions, or authorize the issue of directions concerning the matters listed there. And we submit that the powers are broad and they are aimed at ensuring effective and efficient disaster management in situations where decisions must be taken quickly, particularly, Lord and ladies, particularly, as I said at the beginning of my argument, in this pandemic situation, in order to protect the public. They need to be broad enough to cover a broad range of disasters and to permit the relevant persons to take steps necessary to adapt to and deal with that disaster. It is in light of that the term necessary must be interpreted. In a situation of disaster management, the designated minister is required to formulate regulations to contain the effects of that disaster and to protect the public. Whereas here, the disaster is a pandemic of a new and voracious disease, the minister is tasked with making regulations to contain the effects of that disease and ensuring that it does not overwhelm our public health system. And we say the obligation is also augmented by the government's obligation in terms of Section 7, subsection 2 of the Constitution to protect, promote, and fulfill the rights in the Bill of Rights, including the right to life and the right of access to healthcare services. The state is also required in terms of Section 27(2) of the Constitution to make reasonable measures to achieve the progressive realization of the right of access to healthcare services. Yeah. But more importantly, the state has a duty to take steps to prevent the spread of the disease and to reduce the burden on the health system so as to ensure that those who need these services can have access to them. This duty is particularly acute in the pandemic situation in which we currently find ourselves. We conclude by saying that the minister is therefore constitutionally required to take decisions concerning lockdown regulations with this duty at the forefront of her mind. These constitutional obligations also form part of the relevant context within which the term necessary must be interpreted. Now, we further say, Lord, my ladies, that it cannot be required that the designated minister show proof of necessity in the sense of absolute certainty that unless the measure in question is imposed, the health system will definitely collapse. If the minister were to wait for such definitive proof, she would almost certainly be in breach of her constitutional obligation to promote and protect the rights to life and health care, as she would have failed to be sufficiently proactive in preventing the risk to the public from materializing. She would also have failed to take reasonable measures to realize the right of access to healthcare services. To read the provisions in this manner would thus render them unconstitutional, and we submit that this must be avoided. Lord, my lady, the rest of our submissions are in our heads, and yes. 132. Yes. Okay. Except for just moving on to 132, 01368. As to what this means, some guidance we submit may be drawn from the meaning of reasonably necessary in law concerning implied powers. The power to do that which is expressly authorized includes the power to do that which is reasonably necessary for the proper carrying out of the power expressly given. The proper approach to determining whether powers are reasonably necessary for the powers expressly conferred is set out in Claremont Union College, where we say, courts of law consider the matter from the point of view of reasonableness. They must not hold that an act of a corporation is ultra vires upon a narrow interpretation of the powers contained on the corporation by statute. They must look at all the circumstances, and especially to the consequences of holding the acts to be ultra vires. Then we mentioned the case of G&H, Office Automotive CC, quoting from Baxter, the powers may be presumed to have been impliedly conferred because they constitute a logical or necessary consequence of the powers which have been expressly conferred, because they are reasonably required in order to exercise the powers expressly conferred, or because they are ancillary or incidental to those expressly conferred. And we also refer to the matter of Mulea, in which His Lordship Justice Van Zyl described the test as follows: applying the principles applicable to the interpretation of statutes, it is clear that if certain conduct is required or authorized, the authorizing act should be interpreted as impliedly including authorization to do that which is reasonably necessary to achieve the main purpose, or to perform the action effectively, or that which is reasonably incidental or reasonably ancillary to those powers expressly conferred. And we draw guidance from that approach and make the following submissions. For the tobacco sales ban to be reasonably necessary does not require absolute or conclusive proof that without a ban on tobacco, the healthcare system will inevitably collapse. What it does require is that the minister must have a reasonable basis on which to conclude that without the prohibition, there's a real risk to the health care system, thus rendering the prohibition necessary.
Mr. Morane, I've been very patient, but I'm sure it has to stop somewhere.
Yes.
Talk about the reading.
Yes. Well, my Lord, ladies, we go on to justify that particular reading of the act. I shall stop there, because in any event, what we say is on black and white.
You may refer us to those paragraphs, but as I said,
yes. Yes. No, it's not necessary to continue reading. But in any event, I commend the rest of the paragraphs to indicate what we regard as the proper interpretation of the words that appear in sections 27(2)(n) and 27(3) of the Disaster Management Act. And we conclude by saying that the test, that even if the test is one of strict necessity, we submit that it has been met, as we submit in paragraphs 136, sub 1, sub 2, sub 3, Well, with regards to this question of necessity in our supplementary heads, we, at paragraph 27, we say FITA seems to support a narrow interpretation of necessary on the basis that according to FITA, the minister's powers are not subject to constitutional restraints or parliamentary oversight. Firstly, our answer is that is actually not FITA's pleaded case. Because had FITA pleaded that case, the respondents would have answered it and pointed to oversight mechanisms. And the respondent's answer would have included that oversight is exercised in terms of the Constitution. It's not required that every legislation should set out oversight functions. That the State of Emergency Act does not mean that every instance where legislation does not say so, there's no parliamentary oversight over executive exercise of power. The respondents would also have pleaded instances where oversight was actually exercised during the lockdown. In any event, we submit that there are actually two cases pending before this court in which that issue is raised, and all the relevant evidence will be pleaded. We refer to the case of the DA and the Freedom Front coming before this court next week. The DA has approached the Constitutional Court for direct access, and Constitutional Court has directed the parties to file heads of argument by the 12th and then decide whether or not to direct access. We submit that it would be inappropriate for this court to decide the issue of parliamentary oversight in the present case where it is not pleaded at all, instead of leaving it to be decided by this court or the Constitutional Court in due course. Lord and Lady, we now deal with the question of substantive rationality. It's on paragraph 32 of our supplementary head. Say that FITA makes three principal submissions in relation to substantive rationality. I've already dealt with that in our original heads at paragraphs 46 to 86. Substantial part of our original heads deal with that issue. But in this supplementary heads, we'll just touch on a few matters. FITA submits that there are at best views expressed that smokers might react more severely to the virus, which might possibly result in an increased burden on the health system. And we submit that this misstates the factual position. According to the opinions of those more qualified than FITA or lawyers, the evidence is clear that smokers are at heightened risk of developing a more severe form of COVID-19. And this we address in our main heads at paragraph 59 to 69.3. FITA says it's common cause that the evidence is inconclusive. We submit that that is not correct. Though the minister quite frankly and fairly indicated that the science in this area is still developing, there's no admission on the papers that the evidence that smokers are at heightened risk of developing a more severe form of COVID-19 is inconclusive. Rather, what is said is that the emerging medical literature indicates that smokers are more likely to develop a more severe form of COVID-19. And that the view the Minister has taken of the import of the relevant literature is shared not only by members of the South African medical fraternity and experts in the relevant fields, and we mention who those experts are.
Yes, I think those aspects are all mentioned, but
yes.
You heard what Mr. Subel argued, that even looking at what the World Health Organization has said, this is all inconclusive and can never grant rationality to the decision to ban tobacco products.
Yes.
I would like to hear you on this.
Well, firstly, we dispute that the evidence is inconclusive. In fact, in the portions that Millennium quoted from what the WHO itself says, there was nothing inconclusive about that. The WHO pointed to the probability of certain eventualities. Court will bear with me. Yes. For instance, Lords and ladies, if we refer to 008, page 341.
341.
341. One particularly WHO. Yes. That the possible mechanisms linking smoke to the outcome of COVID-19 were under study. A recent review suggested smokers are vulnerable to respiratory infection because of impaired immunity. Smoking can upregulate angiostensin converting enzyme, ACE2 receptor, the known receptor for the severe acute respiratory syndrome, SARS coronavirus, and possibly SARS-CoV-2 causing COVID-19. The results of the updated meta-analysis further confirm the impact of smoking on the severity of COVID-19. Yes. We also refer to 008195, that is document by the World Health Organization, Smoking and COVID-19 Scientific Brief, that the harms of tobacco use are well established.
You're testing my patience, Mr. Moran. You
Lord,
can make the submissions. We can read these things. I think I said so.
I thought His Lordship wanted me to counter.
Yes, but not by reading. I think you can make your submissions. Submissions are there. Tell us where they are. It's true. I wanted you to counter them, but I didn't say read.
As my Lord pleases.
Yes.
Then it's to be found, my Lord, at this smoking brief. Yes. And the conclusion, page 008198. And the conclusion is that the available evidence suggests that smoking is associated with increased severity of disease and death in hospitalized COVID-19 patients.
Mr. Milano, can I just intervene for a moment? Because I understand the purpose. The purpose of the tobacco ban is to ensure that our health system is not overburdened. We know the constraints on the health system, I accept that.
Yeah.
But the tobacco ban is directed at the sale of cigarettes. It's not directed at the ban to smoke. In other words, people can continue to smoke.
That is so.
If one accepts for a moment that people who smoke are more likely to be hospitalized, as is the argument that you're putting forward,
Yes.
how does a ban on the sale of tobacco achieve this purpose where people still smoke? Some people are fortunate enough to stock up on cigarettes, so they are going to continue to smoke.
Yes.
Those who cannot can, in many instances, access the black market and buy cigarettes there.
Yes.
So my question simply is, how does the ban on the sale of smoke, in circumstances where people are not going to stop smoking, achieve the purpose of alleviating the ban, or the impact on the health system?
Milady, the purpose of the prohibition is obviously to reduce the availability of cigarettes. Admittedly, it cannot totally restrict the availability of cigarettes. But it has the potential, not only the potential, but the effect of reducing access to cigarettes, as the studies have shown, both the HSRC study and the UCT study. It has had that effect of reducing the availability of cigarettes and therefore reducing the smoking of cigarettes. It doesn't completely eliminate it. It was never intended to completely eliminate it. That's an ideal which can never be achieved. But we submit that if in fact there's a reasonable possibility of reducing the smoking of cigarettes, that assists in preventing the overburdening of the health system. And we refer in this regard to NDZ 5008156. And the fifth paragraph, where the following is stated: the current ban on the purchase of tobacco products during the lockdown is therefore a crucial element of trying to reduce the impact of the virus on patients and the healthcare system. At current capacity levels, the South African healthcare system does not have sufficient ventilators. Hence the emphasis of government to flatten the curve and limit the spread of the disease. At current conservative estimations, if even 1% of South Africa's 8 million smokers were infected, and 5% of these required ICU or high care facilities, the healthcare system would not be able to cope. So that is the motivation by Lady arising from the report of the HSRC as to the effect of the prohibition. It's not a total reduction, but a significant reduction.
I think you may consider answering this when we come back from lunch, but I think that the import of the question is, if you as minister, you admittedly can't ban smoking, but you want to reduce access to tobacco products,
Yes.
because you think that will assist in alleviating the strain. But if you are also aware that, as argued by the applicants, that if you ban legal access to tobacco products, you're pushing people to accessing illicit products. What does that do to your decision to go ahead in any way and ban the lawful products? Does it not impact the rationality of the decision to go ahead in any way? I think that's the question we're asking.
Yes. We submit, my Lord, that it does not impact on the rationality.
Yes.
Because we say any effort, any measure which is directed at lowering the infection rate is rational. We say it is rational. And these studies, in fact, suggest that there has been a reduction. Both the HSRC study and the UCT study, they say there has in fact been a reduction in smoking.
Perhaps what you could also address is, in this context, if you are aware of these variables, not banning at all, is that rational? Is that irrational?
We would submit that not prohibiting at all would not be rational, particularly when the decision maker has considered the matter and come to the conclusion that restricting the sale or prohibiting the sale of tobacco in an effort to lower the number of people smoking would achieve a favorable result, and not taking any action, we submit that might be irrational and a breach of a constitutional duty.
Okay. Should we then take our 30-minute adjournment? We will come back in exactly 30 minutes.
As possible.
Yeah.
They are tickling you on. we were at paragraph 33.2 when the question were raised, which I hopefully answered successfully. Then the point that we make in 33.3, say we note that FITA concedes that there is no need for the court to resolve the different expert views in this matter. But in that context, I think it is important to note that as far as the expert evidence is concerned, the people who deposed directly to the issues include Professor Nyamande, who is an eminent pulmonologist, and Dr. Egbe, who is an eminent researcher and psychologist, and Professor London, who is also an eminent expert on public health. We haven't had any pulmonologist depose on behalf of the applicants, and we are dealing here with something which is to a large extent a respiratory disease. So, although the court itself will not delve into the pros and cons of the expert evidence, I think it is important to note the nature of the expertise that has been put before this court. Yes. Then, in paragraph 34, say FITA contends that the damage to smokers is already done. Their state of health will remain the same regardless of whether they stop smoking during the temporary ban. FITA makes no attempt to engage with the facts the minister has put up on this issue. Contends itself with sweeping statements that smoking during temporary period will not meaningfully or discernibly alter the state of health of the patient. And we submit that that is not true on the basis of the evidence that is before this court. The evidence clearly points out that ceasing of smoking, the benefits of ceasing smoking are immediate. And it was for that reason that the World Health Organization has recommended in its statement on COVID-19 and smoking that smokers take immediate steps to quit. And we refer on this issue to what we say in our main heads at paragraph 80 to 85. Then the next issue which I was questioned about by the court before we adjourn appears at page 35. That FITA argues that prohibiting sales is not an effective means of preventing people from smoking, as illicit cigarettes are readily available. We submit that FITA fails to engage with the evidence and analysis by the minister to show that the ban, in fact, has been sufficiently effective. Simply says the minister's contentions in this regard are untenable. We submit that the answering affidavit explains that a study conducted by the Human Science Research Council indicated that 88% of the people had not been able to purchase cigarettes during the lockdown. And we submit that FITA cannot counter this report And the answering affidavit also explains that even if reliance is placed on the UCT study, that is a study on which the applicants rely, the ban on tobacco sales has been notably effective in reducing smoking. According to that report, 16% of the respondents had successfully ceased smoking during the lockdown. We submit that is actually a significant gain, and that is recognized by FITA's own expert. Now we come to the question of the process that was followed. Consultation, Audi, and legitimate expectation, which is mentioned by the applicants. Well, we deal largely this issue in paragraph 91 to 98.4 of our main submissions, and we're not going to repeat them. But we still make the following submissions. See, the applicants allege or complain that they were actually refused Audi. Now, we say in our submissions that FITA appears to be confused regarding the standard of review. It refers to cases concerning the requirement of public participation in the legislative process and the requirement of Audi in administrative decision making, and then seeks to apply these, in this case, to executive action. We submit that they cannot do that. And we refer in particular to the constitutional case, Law Society, where the court held as follows: public participation in the lawmaking process is a requirement specifically provided for in a constitution that must be met by our lawmaking institutions. But participatory democracy is not provided for in similar terms in relation to the exercise of presidential or executive power. There's no legal provision or principle that even remotely imposes an obligation on the executive to invite the public to participate in its decision-making processes as proposed. I'll not quote the rest of that decision. And that the only case to which FITA refers that has any application to executive action is the Albert case, of which one has a passing knowledge of. However, all the court held in that case was that consultation would be necessary where this was required to render the process rational. It's not the same as a self-standing requirement of procedural fairness. And we submit that the Constitutional Court has confirmed that in the Law Society case. We submit that on the authorities, the minister has actually no obligation to consult in that sense, and it's not required under the Act, and we deal with that in our main heads. Further, even if there was such a requirement, we submit that the minister has in fact consulted with the public, and the applicants themselves made submissions in support of their position, which were considered in the decision-making process. So we submit that the applicants cannot claim that their procedural rights were undermined. FITA also tries to invoke the doctrine of legitimate expectation we submit that the doctrine of legitimate expectation applies only in respect of administrative action, and FITA has not referred to any authority making the ground of review applicable to executive action. In any event, as we explained, FITA's voice was actually heard. It saw the need to make submissions and did so. In reality, its complaint is not that it was not given the opportunity to make submissions, but instead that those submissions did not win at the end of the day. When we submit that, that is really not a ground for review. FITA also says that minister failed to give proper consideration to various factors. We submit that that is not true. We submit that all the relevant factors were considered, and we've dealt with that in our main heads, paragraphs 99 to 109. But if one looks at FITA's complaint, really what they are actually saying is that their submissions were not given sufficient weight. That is really the nub of their complaint. That we submit that the weight to be given to a particular consideration is preeminently a matter of discretion, which the minister must be given leeway to determine. In that connection, we refer to the case of MEC, Environmental Affairs and Development Planning versus Clarison CC. We refer to this in our bundle at 021334. In particular, paragraph 22, where the following is said. What was said in Durban Rent Board is consistent with present constitutional practice, and we find no need to reformulate what was said pertinently on the issue that arises in this case. The law remains as we see it, that when a functionary is entrusted with a discretion, the weight to be attached to particular factors, or how far a particular factor affects the eventual determination of the issue, is a matter for the functionary to decide. And as he acts in good faith and reasonably and rationally, a court of law cannot interfere. That seems to us to be one manifestation of the broader principles explained in a context that does not arise in this case in Bel Porto and Batista. Yes. FITA also once again misconstrues the applicable legal test. It refers to Bantu Brothers, a 1973 decision of the then Natal Provincial Division as authority for the proposition that the minister was required to consider relevant factors. We submit that the currently applicable test is the one in the Democratic Alliance case. We set out the reference in paragraph 100 of our main heads. On that test, we submit that there's no basis for FITA to claim that the process involved or adopted was irrational. Now we deal with the allegation that there was ex post facto justification. And we refer to this as a startling proposition. FITA submits that the record and the reasons are replete with material obtained after the date of the decision. Well, it doesn't point out what the material is. What FITA seems to be referring to is the fact that the answering affidavit, not the reasons and the record, the answering affidavit contains material obtained after Regulation 27 was promulgated. Once again, we deal with that in our main heads at 141 to 142. And the reference to additional material we submit was necessitated by FITA's own action in bringing a new review in its supplementary founding papers to Regulation 45. It will be recalled that the original application sought to impugn Regulation 27. But the new case was to impugn Regulation 45. We submit that it was therefore necessary in defense of this new case and Regulation 45 to attach material to the answering affidavit that was considered after Regulation 27 had been promulgated in deciding whether to continue the prohibition into level 3. Therefore, the inclusion of additional material in answering affidavit ought not to have been surprising to FITA, nor does it amount to an ex post facto attempt to justify the prohibition. In fact, it attests to the fact that additional material was considered after Regulation 24 was promulgated in deciding whether to continue the ban into level 3. We submit, therefore, that it is contrary to what FITA is saying, evidence of good decision making. We then deal with another submission to which my learned friend made, criminalizing conduct. The applicant refers to provisions of the regulations that create offenses and makes submissions to the effect that criminalizing the sale of tobacco products is unlawful. We submit that that is a new case, but a misguided case. The regulations prohibiting the sale of tobacco products are distinct from the regulations that make the contravention of the prohibition regulations an offense. Curiously enough, FITA does not challenge the offense creating regulations under the Act. Its challenge is only to Regulation 27 and 45. And we submit that neither Regulation 27 nor 45 creates any offenses. And neither regulation also criminalizes conduct. Therefore, we submit that the legality of an offense creating regulations is not before this honorable court. FITA's case is not whether the minister acting under Parliament's delegated authority in terms of the Act has the power to create new offences under the Act. Yes. In any event, the creation of an offence for contravening regulation passed in terms of the Act is founded in the Act itself. Section 27, sub 4 of the Act provides that the regulations made under 27(2) may include regulations prescribing penalties for any contravention of the regulations. And Section 59(3) says that the minister may prescribe a penalty of imprisonment for a period not exceeding 6 months or a fine for any contravention of failure to comply with a regulation. Leonard Friend has made very much about what the President did or said on the 23rd of April and wishes the court to draw certain inferences from that. We deal with that, Lord, my ladies, from paragraph 53 of our supplementary heads, where FITA seems to make much of the supposed U-turn from the position expressed by the President in his address on the said date. And they allege that, as my learned friend has submitted, that the Minister's decision to promulgate Regulation 27 must clearly have been contrary to what the Expert Advisory Committee to the first respondent and Cabinet had advised. We submit that that assertion has no basis in the facts. The answering affidavit is clear that the President made this statement based on the view that the National Coronavirus Command Council had taken on the issue at the time. It is also clear that it is not the case that the President and the Minister were somewhat at odds over the issue. After the President's initial announcement was made, further consideration was given to the issue in the light of submissions received and medical evidence, and a different position was ultimately adopted. And this state of affairs is confirmed by Dr. Lubisi in his supporting affidavit, where he says, the statement made by the President in his address on the 23rd April that during level 4 the sale of cigarettes would be permitted accorded with the view that the NCCC had taken on the issue at the time. That view was subject to further consultations. The decision to promulgate the prohibition on the sale of tobacco products in Regulations 27 and 45 was endorsed by the NCCC before those regulations were promulgated. And we submit that Dr. Lubisi is eminently positioned to give this evidence. He has personal knowledge of these matters because he attends NCC meetings in both his capacities as Director General in the Presidency and as Secretary to Cabinet. Now, in relation to the advisory committee that was mentioned by our learned friend, this is a ministerial advisory committee that advises the Minister of Health. Minister of Health was one of the cabinet ministers consulted on Regulations 27 and 45, and the NCC endorsed the prohibition on tobacco sales products. Therefore, we submit that the attempts to paint the minister as having overturned the NCC decision or the President are not rooted in fact. Then there's something which is raised by the applicants in their replying affidavit that the President has admitted that he has no empirical evidence to support the ban, and that refers to a press release attached as R1 to the replying affidavit, and we submit that that is demonstrably false. This is actually a Democratic Alliance press release and states that, and I quote, the Democratic Alliance in a written parliamentary question asked the President on what empirical evidence did the National Coronavirus Command Council rely to collectively ban the sale of tobacco products during the national lockdown to curb the spread of COVID-19. Instead of providing any shred of empirical data, as the question requested, the President responded that the ban was based on the submissions received and relevant medical literature focusing inter alia on the effects of smoking on public and individual health, especially in the face of a respiratory illness such as COVID-19. The DA press release concludes from this response that the President admitted that he had no empirical evidence to support the ban. It reasons that President Ramaphosa's failure to produce any evidence is a clear indication that there wasn't any empirical evidence to support the ban in the first place. This is the sole basis on which the claim that the President admitted not to have evidence is based. My Lord, my ladies, we submit that this is just politicking. Now, we deal with the remedy. FITA seeks, in effect, an order substituting the Minister's decision to prohibit the sale of tobacco products to 11.3 and 4 with a decision not to do so. To succeed in procuring that relief, we submit that FITA must allege and prove that the relief is appropriate in the circumstances. Substitution orders are provided for specifically in PAJA. However, since FITA review is not PAJA, we consider FITA submissions in this regard must be based on provision in the Constitution, that is Section 1721B. This requires FITA to show that a substitution order would be a just and equitable order in the circumstances. And we submit that FITA has failed to provide any factual or legal basis to support a substitution order as just and equitable remedy that would be warranted in the circumstances. We submit that it's the Minister that is the functionary empowered by the Act to make regulations during a national state of disaster so as to protect the public. Where she is found to have acted beyond the ambit of the power, it's not appropriate for the court to usurp the powers conferred on her. We submit that the proper course in that case would be to afford the Minister an opportunity to correct her action and remedy the extent of the invalidity. And that would uphold the principle of separation of powers, and the court would have fully discharged its role as guardian and enforcer of the rule of law. It's unnecessary to grant a substitution order. The court should not be seen to be imposing its preferred regulation of the disaster. And this matter, we submit, found expression in the secret ballot case. Which held that the Minister will not act in line with the legal position and conditionalities. In other words, the assumption that the court should not assume that the Minister will not act in line with the legal position and conditionalities as may be clarified by the court. Therefore, we submit that it would not be just and equitable to grant the relief that the applicant seeks. And we deal with those issues in our main heads, paragraph 150 to 153. Well, the next section in our heads we don't need to deal with, my Lord, my ladies, because as has been conceded, this is not an issue relating to fundamental rights. Court will bear with me for a second. Well, so just to round up the point of the remedy, as we say in paragraph 151 of the main heads, that should the court find that the regulations 27 and 45 are unlawful or invalid for any reason, the appropriate, just and equitable remedy would be to refer the matter back to the Minister for reconsideration, possibly with directions as to the information or factors to be considered. We say the evidence is that smokers are more likely to develop severe disease with COVID-19 compared to non-smokers. This in turn increases the strain on the public health system by increasing the number of people who will need access to resources such as ICU beds and ventilators. These are real risks and become even more serious as infection numbers continue to rise. Lord and ladies, practically every day, we see the increasing numbers of people affected by COVID-19. We see the escalating numbers of deaths as they continue to rise. So we conclude. Yes, and what we also notice, Lord and ladies, is that the daily ratios are also rising. But in conclusion, we say that if the court considers the decision-making process to have been flawed or based on incorrect facts, it would be just and equitable to suspend declaration of invalidity pending reconsideration. That would serve to ensure that should the ban on further reconciliation be deemed necessary, the public health gains over the last few months would not be undone in the interim. Lord, ladies, those are submissions.
What are your submissions on costs?
On costs, we are certainly not asking for costs if we succeed. Although the matter raised stricto sensu is not a constitutional challenge, but we submit that the considerations mentioned in BioWatch would be that this is a matter of public interest, and we are certainly not asking for costs.
Okay. Thank you very much, Judge Morana.
As court is this.
Advocate Subel, any reply?
There were three topics that were answered. The first is the question of the remedy, which was dealt with at the end of our presentation.
Yes.
Which I can just do on the basis. Firstly, it's not a review in the sense that there's been a misdirection in relation, for example, to tender, how you score, what weighting. This is an order declaring, it's declaratory relief, declaring that A, it's not illegal, and B, that those regulations which purport to prohibit and render illegal the sale of cigarettes and tobacco are invalid. isn't a constitutional remedy, it's not a pudger. We also allowed that under Gijima in the Constitutional Court has held that pudger doesn't in fact apply to the state. So we're dealing squarely with the legality, but it's a legality in a very narrow sense of simply declaring that a prohibition is invalid. And that's on the basis that it's ultra vires or it lacks rationality. If we just test our learned friend's suggestion that it should be referred back for reconsideration, and I'll ask rhetorically, reconsideration of what? We know exactly what the material is upon which the decision was based. We have it. The second respondent has put up what she relied upon. There's no need to go and reconsider that. If in time there's evidence, or whatever the circumstances are that might change, consideration will no doubt be given at the responsible time in a responsible way to a responsible regulation. But there's nothing to refer back to reconsider. The court is in as good a position to determine on these papers that we have all the evidence that's required, and there is only one inevitable outcome. And the inevitable outcome is there is not sufficient to make this regulation prohibiting. So with respect, this is not a case where it's appropriate to simply delay the matter and refer it back for reconsideration and let the matter drift there. This is a matter where the court, with respect, would be justified in simply making the declaratory relief that is sought in our notice of motion. There were then two central themes that were raised by questions from the court to our learned friend. And the one was the link, if any, between the banning of sales and the cessation of smoking. And the question was asked by Her Ladyship Justice Basson, where's the evidence of that link if we accept that smoking will continue? And the only answer given by our learned friend was, well, we accept that it won't stop smoking, which is a recognition that there will be criminal conduct because people will, as time goes by, be sourcing illegal products. But he said it's good enough on a reasonable possibility threshold test that maybe certain people will stop smoking, and that's good enough. Well, that can't withstand analysis on any basis. Firstly, we know that the test is a very strict one. This is not legislation in the traditional sense, and the Constitutional Court did make it plain that when you interpret the DMA provisions, you've got to adopt a narrow approach for very good reason. Because you're now acting outside of the normal process of parliamentary oversight, where there's public participation in relation to legislation, and all the checks and balances that are normally in place in relation to legislation are now absent. So of course you've got to take a narrow test. And even our learned friend's submission that there's evidence that a reasonable amount or some amount or number of people have stopped smoking is with respect simply not borne out by the evidence they rely upon. And my part then, before I move on, I just want to say something about a learned friend's submission that what the Constitutional Court said was arbiter. It wasn't arbiter at all. It's an impertinence to label this arbiter, because in fact what the Constitutional Court said by way of ratio was that when you come to interpret the powers of the municipality in relation to how far can they go in legislating, because they said it's necessary to give effect to the objects of the DMA by providing in our subordinate legislation for evictions and demolitions. And the court, in interpreting the word necessary, found that was not necessary. This is really, the DMA is there to put out fires. It's there to deal with a disaster on a pro tem basis. It's interim. It's there to deal with things that are necessary in order, and I've already addressed the court on section 26, read with 27. Now, the test for necessary means just that, it must be necessary. Now, what our learned friends rely upon, when he makes a bold statement, as the second respondent does, that they were supported by the WHO in the rationality argument. May I take the court very briefly, without reading documents unnecessarily, but may I just take the court to what the WHO documents actually say, to show that there's no merit in the contention that they've established. Firstly, a connection between smoking and an increased risk, and therefore burden. And then when I get to the HSBC, I'll demonstrate that that is also a thoroughly unreliable basis to base an argument that there's a link between the banning and the cessation of purchases and smoking. So may I just start, and I just want to give the court some references and highlight it. Firstly, in DZ5, in the answering affidavit, it's in volume 8, I'll just get the page number, 193.
DZ5.
Yes. Sorry. 156. Oh, I seem to have two different page numbers. It may be 008156. Anyway, it's in DZ5 to the answering affidavit. And what the court will firstly observe is that this, which was 8th of May, it came after the April events, but very importantly, no mention was made of this in the second respondent's initial reasons for decision. I just want to give the court the reference where you'll find it in the record. So the summary of submissions originally made, the court will find in volume 005-1976. As part of the documents that were made available by the second respondent, and there was no mention there made of the HSRC, and we'll see also how she dealt with WHO in a moment. Now, if I can just give the court references, the HSRC study, our learned friend submits boldly that both that and the UCT study support a conclusion that there was success in the banning because it reduced the number of sales. Well, with respect, firstly, we would ask the court to have particular regard to what West has said in volume 10, at page 103, following, where he explains that A, the period of time that the HSRC did the study, 1. 2, the absence of any supporting data or information that you would need, and the inconclusive nature of it all shows that realistically you can't find that there was a reduction. And it's not a sustainable reduction. The important part is this. The initial reduction in sales was because at that point in time people had stocked up. And also, if people quit temporarily, West, who treats drug addiction and tobacco addiction, explains that this isn't going to be sustained. So there's very little value in taking a snapshot of the very early days of the lockdown and concluding from that that the evidence has shown that the ban is successful in stopping trade. And these numbers and statistics are always dangerous unless it's supported. We'd ask the court particularly to have regard to West, not because West gives a different scientific version to the respondents' witnesses. We're not asking the court to resolve the differences in opinion. What we're asking is in regard to the HSRC, that his observations, which are empirical observations, they're common sense observations, be taken into account, because he explains very carefully why no credence can be given to that, and it doesn't support, with respect to a conclusion realistically. And this is from somebody who for many years treats people in this particular field. So you don't have to be a pulmonologist. He is somebody, he's a specialist psychiatrist who treats drug addiction, and a very, very convincing argument and observations. And we're talking about objective, empirical observations he makes in relation to why that survey is unreliable. And on the other hand, he refers at page volume 10 at 106 to 107, he explains why the UCT survey is far more reliable. And what has been shown is that there's If people stopped, it's very temporary, it's recurring. In any event, it's blown way out of proportion by the minister that it had its effect of reducing. But fundamentally, ultimately what this court would ask, we submit, is if you said reduced it, by how much? How many smokers? How many sales less in this world? None of that is clear, and with respect, when we come to weigh it against other matters and aspects, it certainly doesn't withstand scrutiny. So at page 105, what West says in connection with this report, and I'm referring where it says MW71, this is volume 10 at 105. He says, regardless of the actual percentage used, the UCT report shows clearly that most smokers continued to smoke during lockdown, did not successfully quit smoking, and purchased tobacco at inflated prices on the black market. This, together with other findings, lead the investigators to conclude that, quote, the current disadvantage of the ban may well outweigh the advantages. And he talks about other things. Now, I should also, while I'm on this document, return to Justice Posson's question to me about what we say about the submission about the 1% of smokers and the increased or enhanced strain on the health services. If I can just give the reference where this is dealt with, and we submit with respect, it's a common sense observation. At volume 10, page 103.
It would be helpful to us if you gave us case lines references.
Sorry, I can't say.
Case lines references.
I believe it's 103, volume 10 at 103. Yes, I believe that's correct.
There must be a number before the 103.
009, sorry, 010, volume 10, and 103.
Thank you.
Thank you. So it's in West's report, and he says in paragraph Roman 2, he says firstly the HSRC report is flawed because a full manuscript is not available, and that's what we asked for under 3512, which we never got, and therefore the methodology, data and analysis cannot be accurately assessed. One doesn't need to be an expert to make those observations. This isn't a question of determining which scientist or doctor to believe here. This is something that the court with respect can see for itself. One would imagine that would be compiled manuscript or data set, and what is the response when we ask for it? The response is we don't have any of it, also HSRC. It's a rather remarkable approach because it shows that the minister didn't bother to actually call for that data and get her advisors and the experts in the matter to actually assess this. And then he says, to illustrate the burden of COVID-19 and smoking, a scenario is presented wherein 1% of smokers contract COVID-19 and 5% of those require ICU admission. And I hope I'm now going to address Mr. Posson's question to me because he puts us in good perspective. And this could overrun the healthcare system, so says the minister. He says, this presumably assumes that all smokers will require ICU admission at the same time, which is unlikely. The 1% and 5% numbers are also problematic, as it is not clear where they are derived from. There are no studies that have shown 1% of any country's smoking population will contract COVID-19. There are also no studies that have shown that 5% of all COVID-19 positive smokers will require ICU admission, even if they are at an increased risk, as the respondent suggests. He then refers to China, which is ahead of the curve of most of the countries, and he says in Roman 3, if the same numbers were applied to China, for example, which is 300 million smokers, 3 million smokers would contract COVID-19, that's 1%, and 150,000 would require ICU ventilation, that's 5% of 3 million. This is almost 30 times the total number of deaths recorded altogether in China as of the time of writing, which was 4634. It is approximately 3 times the total number of confirmed COVID-19 cases. The method and reasoning of deriving the 1% and 5% figures is, in my opinion, a guesstimate that does not accurately represent the potential burden of the disease among smokers and does not accurately represent the potential burden of smokers with COVID-19 on the healthcare system. And we submit this isn't something that one needs to be an expert on. What he's observing is purely saying, looking at your own document, it makes no sense. So the HSRC, with respect, has absolutely no probative value and certainly cannot be sufficient for a rational, right-thinking person to make an informed decision of the drastic nature that we've seen here. So that's as far as the 1%, 5% is concerned. It really is playing games with numbers and with respect doesn't stack up and is not supported in any event. So if that fails, with respect, is another gaping gap in the respondent's argument. Let's see what the respondent's version is about the WHO. And I referred earlier to NDZ5, but may I pick up the later WH that the respondent puts up in their volume 8, it's 008-193 and 008-195. And these are the two WH documents, one's 11th of May 2020 and NDZ9 at 008-195 is at 26th of May. That's the most recent that the respondent relied upon. Let's look at this. I'm not going to reread 193, I did that earlier today. That's inconclusive. And if I can take the court then to 008-195, which is the latest. And let's test our learner friend's argument where he says that Peter is incorrect in saying that at best the evidence has been inconclusive. Well, let's see what the WHO themselves say. I'll show the court that in every one of these categories, risk of being infected, risk of being hospitalized, risk of death, all in relation to smokers, every one of these, the WHO has pointed out that the evidence isn't there and indicates that proper studies would need to be done in order to consider that fully. So let me start with 195. They deal the second paragraph on the background. This review therefore assesses the available peer-reviewed literature on the association between smoking and COVID-19, including 1, risk of infection, and these are the 3 categories I've just indicated to the court. Risk of infection by SARS-CoV, 2, hospitalization with COVID-19, 3, severity of COVID-19 outcomes amongst hospitality, and so forth. And the last category is obviously what the second respondent needs to rely upon to show that there's some rationality. I won't read all of it because the court note can read itself, but 196, let me read what they say about the first category. The risk, what is the risk of smokers being infected by SARS-CoV-2? There are currently no peer-reviewed studies that have evaluated the risk of SARS-CoV-2 infection among smokers. Let's just stop there. No peer-reviewed studies, and West points this out, but it's a very important issue because one would have expected then at least an amber light to be switched on for the minister. This research question requires well-designed, population-based studies that control for age and relevant underlying risk factors. So that's inconclusive. And when I submit earlier inconclusive, I do it on the basis of what I read from their own material. Our learner friend to simply argue, without any reference to his own papers, that we are wrong. With respect, there's no merit in that, because their own document which they rely upon in the first category shows it's inconclusive. Let's look at the second one. What is the risk of smokers being hospitalized for COVID-19? Not very different. There are currently no peer-reviewed studies that directly estimate the risk of hospitalization with COVID-19 among smokers. However, 27 observational studies found that smokers constituted 1.4 to 18.5 of hospitalized adults. 2 meta-analyses have been published which pooled the prevalence of smokers in hospitalized patients across the studies based in China. The meta-analysis by Imani et al. Analyzed and so forth. There's no conclusion, there's no peer-reviewed study, there's just nothing here. Next one, what is the risk of severe COVID-19 disease and death among smokers? And then there's a discussion here. And the court will again see, reading this page in 197, similarly inconclusive. And then, very importantly, at the foot of page 197, is what the WHO says are the limitations in what they say. Hospital-based studies that report patient characteristics can suffer from severe limitations, including poor data quality. Collecting smoking history is challenging in emergency contexts, and severity of disease is often not clearly defined and is inconsistent across studies. Such studies are also prone to significant sampling bias. Characteristics of those who are hospitalized will differ by country and context, depending on available resources, access to hospitals, clinical protocols, possibly other factors not considered in the studies. Further, most studies did not make statistical adjustments to account for age and other confounding factors. We know what those are. Those are the comorbidity conditions that we've read about. Well-designed population-based studies are needed to address questions about the risk of infection by SARS-CoV-2 and the risk of hospitalization with COVID-19. We're not imagining when we say that their own material is inconclusive. Conclusions at 198. At the time of this review, the available evidence suggests that smoking is associated with increased severity of disease and death in hospitalized COVID-19 patients. We know from, and that's what they seize on. The second response takes the conclusion without reading the rest of the document and what actually precedes us. Although likely related to severity, no evidence to quantify the risk to smokers of hospitalization with COVID-19 or of infection by SARS-CoV-2 was found in the peer-reviewed literature. And this is literature that's been pumped out at an alarming rate around the world since the end of last year. And in no peer-reviewed literature is there any support for this. And that's why, with respect, when we say this is not shared by any other country, we're not undermining the sovereignty of South Africa. What we're saying is there is a great deal of work being done on this on an ongoing basis. There's a race to find cures and vaccines and to understand this disease. And that's why they're saying here, there's no peer-reviewed evidence, there's no evidence to quantify the risk to smokers of hospitalization with COVID-19 or of infection was found in peer-reviewed literature. Population-based studies are needed to address these questions. It doesn't take terribly much analysis on their own version that there's nothing to be said for the prohibition. There's nothing to be said in her reasons. There's nothing to be said in the logic or rationality, or rather absence of it. When you read their own, and this is what she believed swung her, that outweighs all the other enormously prejudicial consequences that flow from this ban. And then at 198, what the recommendation is, from they don't recommend a ban on smoking, not even the WHO do that. They recommend basically encourage people to stop smoking. Well, nobody will argue with that. But what's telling, WHO recommends that tobacco users stop using tobacco. Nowhere have they said, we recommend that countries legislate now to ban the sale of tobacco and cigarettes. And why?
They can't do that. Can they?
Sorry?
Can they?
They could recommend it. Their status is that they can recommend anything. But and no doubt the reason they don't recommend it is because we see what the negative impact is of doing that. So when you rationally weigh that up now against what we say, and we don't say it lightly, the notional, highly speculative basis of what prompted this minister to make the decision to expressly ban it, we submit it's non-existent.
Yes.
Ladyship will just give me one moment. So if we conclude that there is no sufficiently reliable evidence of a meaningful reduction in smoking and link it to a meaningful reduction in the stress or strains that it may place on the healthcare system, with respect, there is nothing left of the argument. You bear with me? I understand my learned friend wants to put something on record. I have no difficulty with that.
Okay.
So perhaps he should, and then I'll conclude.
Advocate Murana?
Very good. To what?
Forgot to put one fact. It's in the bylaws 01115. It refers to the National Directive for COVID-19 Management in India as prescribed in their Disaster Management Act. That's paragraph 6. So that there should be strict ban on sale of liquor, gutka, tobacco, etc., and speaking should be strictly prohibited.
Was it disclosed in the 3512?
Yes.
Okay.
It's on the record. That's possible.
Yeah, I know. I'm just asking how it came in. Did it came via the 3512 request from the applicant?
Yes, it was the response.
Thank you.
Thank you, madam. I'm indebted to madam.
Thank you. Yes, as far as I'm concerned, the court will see it's totally outdated. And questions, and one can establish very easily whether there's a ban. Our understanding is there's no ban in India, and certainly not in Israel. But what you will see is that totally outdated material is relied upon. And as your Lordship correctly points out, it was in response to these guidelines. In response to Rule 35, you'll find it in case lines 011-7. That's India, 15th of April. Thank you, my Lord. My ladies, those are our submissions.
Thank you, Mr. Subin. I want to thank the legal teams for the submissions made. We're indebted, and we're indebted that you use case lines, which is the digital platform that's used in this division. We are going to retire and consider our decision, and once we are ready, we are cognizant of the fact that this is an urgent application. We will try and expedite the judgment preparation process, and the parties will be advised when judgment is ready. And I think in terms of the current times, I don't think we'll be handing down judgment in open court, even though we had it in open court. The judgment will be emailed to the parties.
Thank you.
So, thank you very much. Court adjourned.
Thank you. Yeah. It's weird.